We are consulting on how to make the contempt of court regime a fairer, simpler, and more effective safeguard against conduct that interferes in the administration of justice and undermines the rule of law. So, for example, yelling obscenities at a judge or publishing details of a defendant's prior conviction during their trial. We want to make the law governing contempt clearer and more coherent. So we're looking at liability for contempt, the powers that courts have to deal with contemptuous behavior, procedure in contempt proceedings, and sanctions for contempt. The law at the moment is disorganized and at times incoherent. It's developed piecemeal over time. It's an unsystematic mix of both statute and judge-made law, and it hasn't kept pace with development of social media and the fact that it's easy now for anyone to publish information about court proceedings. What we found is that some courts and tribunals lack meaningful powers to deal with contempt. Where those powers exist, the sanctions that are available are blunt, whether their aim is to coerce compliance with court orders, for example, or to punish bad behavior. The procedural rules vary, as do the routes and rights of appeal. The result is that it's difficult to identify and understand the relevant law, and it's also hard for courts to recognize and respond appropriately to interferences with the administration of justice. We consult publicly so that our recommendations are evidence-based, and we'd like to hear from anyone who's affected by the law of contempt, including those who work in or use the justice system, those with experience of contempt and those who support them, the media, and academics and researchers. We're running a public consultation period for 4 months until the 8th of November, and you can respond via our website by searching for Law Commission Contempt, and there you'll also find details of upcoming consultation events.